You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 33. What is a PCT international patent application and should I file one? My name is Dr. Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com. That's D-I-A-M-E-N-T, patentlaw.com. Or, if that's too hard to remember, you can get through it through patentingforinventors.com. That's patenting, F-O-R, inventors.com. Or you can call me at 424-281-0162. And while most attorneys can only practice in states where they're members of that state's bar, patent attorneys are actually allowed to practice patent law in any state. So feel free to contact me regardless of where you live. I've made reference to what is called a PCT application a few times in this podcast, but haven't gone into the details on what they are. The next several episodes are going to be about foreign applications, and PCT applications are one way of doing foreign applications. If you have no interest in patent protection outside the United States, then you can skip all these episodes. After I cover a few foreign patent episodes, I'm going to go back to the US applications and then cover other foreign patent issues later. The reason why I'm not doing them all together is because I'm roughly doing this podcast in the order that you'll likely do when you're doing your own patent application. I talked about the 12-month deadline after filing your US application, and there's a good chance that you will not have received any correspondence from the Patent and Trademark Office in the US before you have to decide whether you're going to file foreign applications, which is why I'm covering how to file foreign applications before we've gone through the entire patent prosecution process in the US. So what is a PCT application and why are they useful? If I had to sum up this entire episode, it's that PCT applications allow you to put off making big foreign patent application financial decisions about your invention for an additional 18 months compared to if you don't file a PCT application and file all your foreign patent applications directly with each country that you're interested in. That's the big picture. We're talking about 2.5 years of putting off a big financial decision from your US application if you file a PCT application versus only 1 year of putting off a big financial decision regarding your foreign patents if you don't file a PCT application. What PCT stands for is Patent Cooperation Treaty, and it's a single application that can be used to get a patent in most countries throughout the world. What's really important to know is that there's no such thing as an international patent. I have to repeat that because it's really important. There's no such thing as an international patent. Now, this might seem counterintuitive because why is there an international patent application but no international patent? An international patent application, or PCT application, is a single application that can turn into multiple different patents throughout the world. But each country, with a few exceptions, needs its own patent. So there's an international patent application but no international patent. It seems kind of weird, and what does that mean? How does it work? Several countries have signed a treaty called the Patent Cooperation Treaty that says that they will look at one application filed in one place to determine whether your invention is patentable. So what's the big deal? Without this treaty, if you wanted to file a patent in 30 countries, you would have to file 30 different applications in each of the 30 countries, and it would cost a lot of money. Instead, you can file a single application in one place called the Receiving Office, and the U.S. Patent Office is one of the PCT receiving offices. If you file a PCT application, it's kind of like you filed an application in all the countries that are part of the Patent Cooperation Treaty. Currently, as of June 2018, there are 152 countries that are part of the PCT, but it's not every country. So you have to be aware of the countries that are in the PCT and not in the PCT if you're interested in getting patent protections throughout the world. There are about 40 countries that aren't part of the treaty, but most of them are small countries that most businesses don't care that much about patent protection in. But the two countries that aren't part of the treaty that many businesses do care about are Taiwan and Argentina. So if you're interested in those countries, you'll want to talk to a patent attorney about how to get protection there. Technically, Hong Kong is also not part of the treaty, but there's a special way you can get patent protection there by going either through China or the United Kingdom. So you don't have to worry about Hong Kong right away. So how do you file a PCT application? It's fairly similar to filing a US application, but there are some differences. First, if you filed the US application already, you have to file your PCT application within 12 months of your US application. You could also file a PCT application before your US application, which is one type of strategy, and I'll get to that in another episode. But for now, I'm going to assume that you filed a US application. Let's say that you're just starting your product out. You filed a US application, and you don't know whether your product is going to be successful or not, and what countries you might want to sell your product in. Without a PCT application, within 12 months of your US application, you'd have to figure out which countries you want to file in, find patent attorneys in each of those countries, get your patent translated, pay filing fees in each country, pay the attorneys in each country. You could be talking hundreds of thousands of dollars, and you have no idea if your invention is patentable or marketable. That's a big financial gamble that you're taking. So instead of doing that, you file a single PCT application within 12 months of your US application. The filing fees are a little more than the US filing fees. So depending on the size of your application and size of the company, the filing fees might be between around $2,000 and $4,000. But that doesn't include attorney's fees for preparing it overall. So if you filed your US application already, the total cost could be maybe between $5,000 and $12,000, but it depends on a lot of factors. If you've done a US application already, the attorney doesn't have to rewrite the whole thing, so it's not like you have to pay the same amount of money in attorney's fees to prepare your PCT application if you've already done your US application. But since the filing fees are higher, it may end up being around the same cost overall. So instead of paying maybe hundreds of thousands of dollars to get your application on file with 30 or more countries, you can just pay perhaps maybe $10,000 to get a PCT application on file. So let's say you have your PCT application on file, and I'll cover how to submit a PCT application in a later episode. But I've already told you that there's no international patent. So what's the point, and how do you get your single application into multiple foreign patents? The point of the PCT application, as I said, is in the timing of when you have to start paying more money to get your application examined by foreign patent offices. If you have on file a PCT application, you have 30 months, that's 2.5 years, from your earliest filed application to enter what's called a national stage of the various countries. The national stage is when you actually pick the specific countries where you want to get a patent. At that point, you do have to pay the foreign patent offices and foreign patent attorneys. So what's the advantage of the PCT application if you're going to have to pay all those fees eventually? The advantage is delaying a big financial decision for an extra 1.5 years. And by that time, you may have decided not to pursue this patent anymore. Let's say you didn't do a PCT application. You filed your US application. 12 months later, you paid hundreds of thousands of dollars to file in 30 countries. You finally get a response from the US Patent Office saying that your invention is not patentable. Or you decide what you thought was a great product was really horrible, and you're just going to give up on the whole idea. If you filed in 30 countries, you're out hundreds of thousands of dollars that you can't get back because you paid all those fees at the various patent offices and attorneys throughout the world. But let's say you filed a single PCT application at the 12-month mark instead of filing 30 foreign patent applications. You paid maybe $10,000 for a PCT application. Soon after that, you get a response from the US Patent Office that your invention isn't patentable, or you came to a financial decision that you're not going to market this product after all. Then what happens is that you have an option of just letting your application go abandoned. When that 30-month deadline comes around for deciding to file in foreign countries, you can just ignore that deadline. So instead of losing out on hundreds of thousands of dollars, you can cut your losses at maybe $10,000. You might be thinking, well, why not just file in foreign countries directly within 30 months and not use the PCT application at all? And it's because that 30-month deadline only applies if you filed a PCT application. Here's an example. Let's say you filed your US application on January 1st, 2017, and 24 months later you file a Mexican patent application based on your US patent application. The Mexican Patent Office is going to do a patent search and find your US patent application and say that what you're trying to patent is already publicly disclosed in your US patent application, so you can't get a Mexican patent. It doesn't matter that the Mexican patent application is from you and the same invention as your US application. If you miss the 12-month deadline, you're out of luck. If you filed a PCT application that claims priority to your US application and then went to the national stage of Mexico within 30 months, then the Mexican Patent Office cannot use your own patent application against you, or any reference against you that came after your US filing date. In some respects, it's almost like you filed in Mexico on the same day that you filed in the US. Getting 30 months instead of 12 months to decide which countries you want patent protection in is the main reason to file, because it delays any big costs that you might be considering. But another reason is that when you file a PCT application, you get a PCT examiner to review your application and say whether your claims are inventive and patentable. I'm going to go through all that in a future episode, but what's really great about PCT applications is that if you get a positive review from the PCT examiner, when you go to the national stage in those foreign countries, all those foreign examiners are going to see that you got a positive review, and that the PCT examiner thought that your invention was inventive and patentable. Now, it's only a persuasive opinion, it's not binding, so there's no requirement that, let's say, the Mexican patent examiner has to allow your patent. But the Mexican patent examiner may look at the PCT examiner's report and say, well, he thought it was patentable, good enough for me. I'll say it's patentable too. It does happen where the PCT examiner says that it's patentable, but another examiner says it's not, so it's not a slam dunk that when you get a positive patentability opinion from the PCT examiner, you'll get a patent. Also, if you get a negative report from the PCT examiner, it might influence you to maybe not pursue that patent application in foreign countries, so you can cut your losses, or you can respond to the patent examiner. I'll go over more of those details of examiner patentability opinions and how to respond to them and the different timelines and deadlines in future episodes. So who should and should not file a PCT application? If you're only interested in getting a patent in maybe 2 or 3 countries besides your US application, it might not be worth it to file a PCT application because you'll be paying PCT costs, plus later on you'll have to pay costs on those 2 or 3 countries as well. In that situation, it might be better to just file directly in those 2 or 3 other countries, but I'd only do that if you're absolutely sure that you have no interest in getting a patent in any other country. It's not a hard and fast rule, but I'd say that once you're up to maybe 4 countries that you're interested in, PCT is probably the way to go, but every situation is different, and there are reasons why someone might not want to use the PCT to file. If you want help with drafting your patent application, you can contact me through my website at patentingforinventors.com. That's patentingforinventors.com, or call Diamond Patent Law at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com. Or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.